inaasahan na sa isang executive session ay magkakaroon naman ng botohan para gumawa ng final shortlist na siya naman pong ipipresenta kay Pangulong Rodrigo Duterte. Ito pong shortlist na ito ay pagbobotohan ng mga membro, non-members at ng regular members ng Judicial and Bar Council. Kabilang po dyan si Chief Justice Maria Lourdes Sereno, DOJ Secretary Vit Aguirre, isa po sa mga miyembro ng Kongreso ng Justice Committee. It's either po si Senador Richard Gordon o di po kaya ay si Congressman Umali. At kasama po itong apat na nasa loob ngayon ng pangapawang regular member. Kasama po si Retired Associate Justice Angelina Gutierrez, IBP Representative Maria Cayosa, mula po sa Academe na si Ginoong Mejia, at mula po naman sa isa pang sector, private sector, si Ginoong Toribio Ilaw. So inaasahan po natin na patapos na makagawa ng shortlist ang JBC ay ipipresenta po ito kay Pangulong Duterte, at yung shortlist po na yon ay pipiliin yung papalit sa mga magre-retiro na sina Associate Justice Jose Perez at si Associate Justice Arturo Brion na nakatakda pong magretiro sa December 14 at 29, 2016. Kung nakikita po ninyo sa inyong mga telebisyon, formal na pong nagsisimula itong regular members po ng Judicial and Bar Council, at inaasahan na matapos po ang opening prayer at ang national anthem ay uupo na sa public panel interview alinman sa tatlo na nakatakda pong interviewin ngayon. It's either po si Ginoong Romulo Borja, si Ami Lazaro Javier at si Joseph San Pedro. Idagdag ko na lang din po na bukod po doon sa 7 kahapon at yung 3 po na nakaschedule ngayon, meron pang 7 na naka-schedule na matagal nang na-interview ng Judicial and Bar Council. At ito pong 7 na to ay sina Apolinario Bruselas, si Rosemary Carandang, Stephen Cruz, Reynaldo Daway, Alex Quiros, si Ginoong Andres Reyes Jr. at si Ginoong Jose Reyes Jr. So ngayon po, atin pong tunghayan ang nagaganap ngayon na public panel interview ng Judicial and Bar Council.
Thank you very much. Justice Borja, please occupy the hot seat.
And so, this is continuation of the public interview. May we request Attorney Cayosa to start.
Thank you, Madam Chairman. Good morning, Justice Borja.
Good morning.
This is the first time that you have applied for the Supreme Court, although you have been with the Court of Appeal since 2004.
2004.
What made you decide to apply now? Or
now,
even,
this time?
Actually, the better question is, why only now?
Why only now? The Chief Justice told me once that you don't just apply for the sake of applying. It's a decision you don't make easily. In his advice was, make sure the planets are aligned. I thought about that metaphor. It's a terrific metaphor, but I thought of a better one. One should not apply until, like a good bottle of wine, all the elements, the sourness, the sweetness, the texture, the bouquet, have cohered into a pleasant, fine wine. I feel that this is the proper time. I hesitated before, although I have to lay my cards on the table. I applied about 4 years or 5 years ago when there was a vacancy, but I didn't push through with it. So I didn't reach the panel interview stage. The reason is that although I was technically free of any backlog in my cases that time, since then, because of my administrative work, I fell behind, and therefore now I'm backlog free, and that's one of the elements that I thought had to be present before I attempted. And also I feel I have acquired, I hope I'm not wrong, I've acquired a level of maturity that allows me to, impels me to apply this time.
one of the things that we look into is the capability of the aspirant to help in declogging the Supreme Court of its cases. And we would also want to look into how long you would have in order to achieve this goal of declogging the court. The next associate justices of the High Court are expected to have at least 1,000 cases assigned to them during their incumbency. And I was looking at your personal data sheet. You recently turned 68.
I'm 60. I'm sorry. I'm 68 years old. I think I was born 1948. It's
Right. So you turned 68.
68. Yeah, last September 11.
Right. So if appointed perhaps sometime in January, that would leave roughly about 22 months.
22 months.
And I was doing the math. Based on your submissions, particularly your personal data sheet, you have a case disposition of 19 cases per month.
And that's an average over the entire 12 years, yes.
Yes. Now, our concern is if you are to completely resolve the cases that would be assigned to you during the 22-month period, you would have to decide at least 42 cases per month. How do you plan to do that?
I don't plan to do that. I cannot plan to do that without risking my health, Your Honor. 41 cases, to produce 41 cases a month, one has to engage in assembly line decision making. I don't believe in that. Every case must be thoroughly reflected upon, studied, reviewed, and reflected upon. My own average, the target I used, and sometimes I exceeded that, sometimes I fell behind, was 12 cases a month. It took me many years to remove my backlog. If I'm given 1,000 something
Over
cases,
about 1,000 cases. Yes.
I would have to annualize that. How much can I do within the months? In a reasonable, I would target maybe 12 cases a month as a minimum. That I am capable of. Beyond that, I'll be completely stressed out, Your Honor, to be perfectly honest.
So if we go beyond your ability to perhaps help bring down the caseload, what would be your other contributions to the court with respect to improving the administration of justice and also uplifting the legal profession?
I've thought about that for reasons other than this interview and talking to the stakeholders of the judicial system. I can have a whole laundry list of proposed reforms, but I think two strike me as strategic. One is most of the judicial officers express financial insecurity. That is a common theme in talking with them, even at all levels, even at the Court of Appeals. And that erodes your confidence, that erodes your independence, that erodes your integrity sometimes, unfortunately. I feel that the Supreme Court should aggressively pursue an incomes policy for judges and justices, an incomes policy that first divorces it from this pay standardization rule. It should be made to seek its own level depending on its resources and its objectives. That's one. But not only will it improve financial security for those who are in the judiciary, but I think more important, in the long run, it will tend to attract the best and the brightest in the profession to enter the judiciary, because the general feeling is that they're avoiding. And yet we need, I think, the best and the brightest. The other proposal that I have thought over, reflected over a number of times is there are too many sources of delay in our processes, in our procedures. And I think an aggressive reduction or diminution of these sources is imperative. The courts are viewed now as really institutions of delay. I'm sorry to say it, but that is, I think, a sociological fact. Even the executive tends to blame the judiciary for its delay. I think there are many occasions or instances when we can reduce delay. We need to I think out of the box, think creatively. Why is it that in civil cases we allow the one party 45 days to file an appellant's brief, the other party 45 days? That's roughly 3 months. You input the you factor in the delay by the postal services, motions for extension of time to file pleadings and all of that. It could be years. And I think it is unnecessary. When a person files a case in court, he already has a theory of the case, and depending on his ability to prove his case, if he disagrees with the outcome of the case, on appeal he really knows what's going on. He doesn't have to do much research. It is my opinion. That was my approach when I was practicing attorney. I know the case already. I know what I feel, where I feel the trial judge erred, and I'm prepared to write it. Although I was also guilty of asking for motions, of filing motions for extension of time, but it almost became habitual. But I think that should be reduced. That's just an example of where the processes, you can actually speed up the process in many sources without compromising due process.
Thank you, Justice. Now, you mentioned civil cases. Let's zero in on criminal cases, particularly with respect to drugs cases.
Yes.
We have an increase in the number of drugs cases that have been filed with our trial courts. What would you propose as a measure to speed up the resolution of these drugs cases, considering their number, the number that although, like, I guess one of the ways that the Supreme Court has addressed is that it has now distributed the drugs cases to more courts instead of just to designated drugs courts. So all courts now will be raffled. Apart from this, what do you think should be a measure to be taken by the Supreme Court in this regard?
I do not know whether it is within the rule-making power of the Supreme Court or it requires legislation, but in many countries they allow pre-bargaining, and that resolves many cases. We don't allow pre-bargaining right now in drugs cases. Secondly, when it comes to information for mere use, there should be more liberality in allowing rehabilitation. They get it out of the court system, put it in under the Department of Health, because the problem is not legal, the problem is really medical. If you remove all of that, you can actually reduce the dockets of that. That is out of the blue. I am
just two more questions. I see the red light, but I just have two more questions. One is, there are now bills filed in Congress to restore the death penalty. What are your views on these bills?
There are 2 points here, whether the morality of the death penalty, and the other is common in all debates, is whether it really acts as a deterrent to crime. I'll answer the second one first. In most debates, the results, sociological data, economics data even, indicates that there is no clear-cut showing that the death penalty actually deters crimes, regardless of the nature of the crime. So that is still a debatable issue. But on the morality, I have been asked the question many years ago, and my answer was this. In 2002, I received a copy of the Roman Catholic updated catechism, and I reviewed the church's stand on death penalty, and I found that they do not really oppose. I think the opposition of the church in many jurisdictions to the death penalty is they are uncertain of the quality of decision making. They do not want an innocent man to die, and death is so irrevocable. But St. Augustine's theory of defense of the state as a justification for death penalty remains a valid doctrine. So I have no moral qualms about that. Although I'm not a lawmaker, but I do have reservations as to whether it really operates to deter crime. Those are my views.
Thank you, Justice. And my last question. I noticed that in your personal data sheet, your mother's maiden name is Dulce Roa Valdez-Huesa.
Yes.
Any relation to the president?
I've met the present president when he was still a mayor a number of times, but not as president. And we have tried to exchange, what do you call it?
Trace roots?
Trees, our family trees, and it's very difficult. But I know for a fact that his mother had attended a number of ROA reunions in Cagayan de Oro, I think twice. And we do admit that we are somehow related, but we have never been able to put that down. My mother's mother, my grandmother, is a ROA twice over. Her father was a ROA, and her mother was a ROA, although I'm made to understand they're not first cousins.
Thank you. That was my last question. Good luck, Justice.
Thank you, Your Honor.
Thank you, Madam Chairman.
Thank you so much, Attorney Cayosa. May we request now, Judge. Thank you.
Thank you, Madam Chair. Good morning.
Good morning, sir.
For starters, having been in the judiciary for I think about 12 or so years, what do you think are the problems that presently plague our judicial system?
I tend to think structurally rather than specific solutions. I mentioned the economic problem. It's a recurring theme in all my discussions with judges and justices. The recurring theme is financial security. And I think that creates a big hole in their lives, an economic hole. It's very hard to get out of. I think I suggested that the first reform is to have an incomes policy. An incomes policy is a policy which rewards productivity, rewards productivity and maintains a security for life or until the end of their term that will allow them to focus on their work, not on earning money, but on their work. And that is a major factor in for many judges and justices. And the other one is there's a great room for the reduction of delay. I was the presiding justice of the Court of Appeals, assigned me as one of the members of his committee against delay or anti-delay committee, and in the process I learned many areas where you can actually reduce delay. I don't think I should go into the entire laundry list.
Of cases, in the letter of Attorney Reyra Agas, chapter president of the Integrated Bar of the Philippines in Misamis Oriental, he mentions that you have competently served, and I am now quoting from his letter, the appellate court has provided sterling leadership to its Mindanao station, resulting in the reduction and elimination of case backlogs. And that's what I wanted to ask next. Can you be more specific on how you went about reducing and managing your caseload and backlog that was with your court when you assumed?
With respect to that letter, the Cagayan station suffered a lot of headwinds, principally because of a very high turnover of justices. We are the entry point for justices of the Court of Appeals. So this is where they learn. This is boot camp for them. This is, how do you put it? This is where they learn to be justices of the Court of Appeals. And so when they start out, they don't start out running. They have to gain speed. And yet, there is a very high turnover. Once they learn they learn the ropes. They tend to move on to Cebu or to Manila, so we suffer from that. That's a major headwind. We were able to change that first, but we insisted that there will be no transfers from our station to any other station until the replacements are already available. In other words, once the JBC had already, the president had appointed the replacements, then they'd be allowed to move on. This caused a lot of consternations, but ultimately the justice were understood the reasoning behind it, and we have followed that. That helped a lot. How did I manage? How do you manage other justices? It's kind of quite difficult. But what I do is that every month, at the beginning of every month, I give them all a copy of their output and their backlog and their deficits for the month, without telling them anything, and they respond. And I have to say, generally they respond very well. They feel the pressure. And the third part is our presiding justice, Justice Andres Reyes, has also focused a lot on the elimination of the backlog. It has been his drive for the past, 4 or 5 years, and I have to congratulate him in public if I have to. It has produced results, and almost the entire court is we're this close to a backlog-free court. And it just happens that in Cagayan de Oro, in the Mindanao station, our problems in that respect are greater. But we have, I think, succeeded. I think that's the point that Mr. Agas mentioned, because that was raised oftentimes by the IBP, the fast turnover of justices and the delays that were incurred because of that.
Early this year, there was a news item where you and other Court of Appeals justices have been accused of receiving bribes, quote unquote, to further the interests of Mayor Oscar Moreno of Cagayan de Oro. We would like you to give the opportunity to tell us about this particular incident.
The case is still pending, I think, on a motion for reconsideration. I do not know if I am completely free to do that, but I deny that completely, and I challenge those who made the accusation to come up with evidence, and I was prepared to act on the evidence. Mayor Moreno is married to my aunt. She's a Parado, I believe, and I have inhibited from the case. And however, I will defend my justices because I have a good set of justices. I think the entire court has a good set of justices, but they are conscientious and they do not accept bribes. I have to reject that accusation completely.
Thank you. Let me just ask you one of the Twittered questions addressed to you. The Supreme Court recently reversed your decision on the ban against aerial spraying of pesticides. What can you say on this?
Yes, I was the sole dissenting opinion in the court in Cagayan de Oro. But the majority opinion was not reversed. I'm sorry. It was actually affirmed by the Supreme Court. I was the sole dissenting. So yes, did it reverse me? Me personally, yes. And I'm very saddened by that. I thought I had made a strong case for the affirmation of the trial court's ruling that the ordinance banning aerial spraying was constitutionally valid. I'm sorry to say, but I maintain. I do not wish to say this, but I think the Supreme Court was wrong. And it was, I'm sorry to say also, it was unanimous, unbanked decision of the Supreme Court, so it's a real slap in my face. But I'm sorry, but I do maintain that the aerial spraying that was banned by the ordinance posed a grave health risk. Not on the plantations that were being sprayed, but because of wood rot it tended to affect others who are not involved in the plantation. And I thought the air above this plantation is public space. And it could be regulated. It could be and should be regulated. And I thought that was the point of the ordinance. My feeling is that the Supreme Court applied legal formalism. The law was overbroad in that it did not distinguish harmful from non-harmful insecticides, and therefore it was overbroad. And I have my reservations about that. But I yield. The Supreme Court has spoken. I understand.
Thank you. That was my final question. Good luck,
Thank you,
Justice
sir.
Borja, and thank you, Madam Chair.
Thank you, sir.
Thank you so much, Attorney Mejia. May we request no judge.
All right. Thank you, Justice Gutierrez. Good morning, Justice.
Good morning, sir.
You are based in Cagayan de Oro.
I am.
And why the sudden change of applying as an Associate Justice of the Supreme Court in Manila?
Well, one of the reasons that I stayed in Cagayan de Oro was, to be perfectly honest, when the Cagayan de Oro station was set up in 2004, then Chief Justice Davide was our speaker, and he mentioned this, and I think I can quote him, I can still quote him verbatim. He said, "I wish the justices of the Cagayan de Oro station of the Court of Appeals will make a career out of staying in Cagayan de Oro as justices." And he mentioned my name in particular, so including, I used to be a dean, and he knew me, so including Dean Bora. And I guess I heeded that. But there's another reason, and I have to be frank here. My children were very young. I married late, and my children were quite young. And I needed for them to grow up in a less stressful environment than in Manila. And although I wanted them to study in Manila, I wanted also them to have a pleasant family home, family life. And we have good schools in Cagayan de Oro. That was the other factor. But they're mostly grown up now. And yes, I can live in Manila.
Precisely, there will to be a change of environment. Imagine from a paradise going to non-paradise to the traffic, alleged decongestion in Metro Manila.
Your Honor, one weighs these things, lovely existence in Cagayan de Oro against what is every lawyer's dream, the Supreme Court. Well, you weigh these things, and I weighed it in favor of this application.
All right, another point. You have been unanimously endorsed by the Associate Justices of the Court of Appeals Mindanao Station for the position of Associate Justice of the Supreme Court. How and why do you think you were able to garner such vote among the associates?
First of all, let me say that was a surprise. I do not know who started that. But just one day they said, "I have this." And I was flabbergasted by it, to put it in strong terms. But there are two possible reasons, Your Honor. One possible reason is this is a kick upstairs for them. Maybe they wanted to get rid of me. So this is one way to do that. But I think it was sincere. I think they meant it. I don't have a very aggressive managerial style. And maybe they appreciated that because my administrative style really allows them more room to be themselves. Maybe that it is that. I hope it is not a kick upstairs.
Anyway, the letter also commended your free from corruption and strict fidelity to moral and ethical standards. What action points did you take to merit such strong commendation from your colleagues?
Generally I don't talk to litigants when I cannot avoid their visiting me in the office. I always make sure that one of my lawyers accompanies me there. So if I could, I'd probably record our conversation. I don't allow them to talk to me. I talk to politicians who came and some of them are my friends, so I allow them to talk. But the minute they talk about any case, and I completely shut it down. I have many friends, and even before I joined the Court of Appeals, I have many politician friends. My father was a former mayor of Cagayan de Oro. They say it's one of the most beloved mayors there, and that political capital is there. But I've never been a politician. But there's also the possibility of their asking me for favors. But I have made sure that our relationship remains on a purely protocol basis. They are politicians, they deserve respect from me. When they talk about the possible cases, I told them, I'm sorry to say, but I shut them down. To their credit, the politicians of Cagayan de Oro have respected that. And I'm very happy. They have not made a habit of approaching justices for cases. And I'm very glad for that.
Does it speak for a relative withdrawal from the society?
I'm sorry,
Most of your friends, relatives, and neighbors in the community?
No, withdrawal meaning I don't deal with them. No, I remain a member of at least one Rotary Club. That's probably my only engagement in social life. I'm a homebody. I'm sorry to say, I'm a homebody. The only outings we've had is mainly with the court, the justices of the court, and maybe with our staff. Aside from that, aside from old high school friends, we meet occasionally for a reunion. Even then, no discussion of cases, ever.
All right, I am really reluctant to ask you about this. And out of the applicants, you are among the few who had many or more than 2 or 3 administrative cases. What can you say about this? That is not be inconsistent with the endorsement by the Court of Appeals from Mindanao Station.
I've had one administrative case and that was it, Your Honor.
Only one?
Only one.
And can you specify what case is this?
This was filed by my cousin. The background is this, if you may indulge me.
Yes, please, in brief.
I'll be brief. Before I joined the court, I was the chairman of the board of our company, a family corporation. And after I took my oath as justice in a subsequent meeting of the board, I told them that I have studied the rules, the ethical rules on the matter very carefully. And I found that there was no clear-cut, no what they call bright line prohibition, especially if it is a family corporation, and this was clearly a family corporation. So I told them, if you want me to stay, I will stay, but if anyone objects, I'm out. And they unanimously said, we'll keep you, we don't want you to go. So on that basis, I continued. After about a few months, this case was filed, and immediately I said, oh, one objection, I'm out, and I resigned from all my corporate engagement, but mainly chairman of the board of the company. So they filed the case. The case was dismissed for lack of merit in we call it a minute resolution.
All right, thank you. All right, having been both practiced in the private sector and in the government, you have perhaps observed and noted the disconnection between the two practices, as a private practitioner and in the government practice.
You're asking, Your Honor, the connection or?
Yes, please, the disconnection.
Explain the connection. Private practice is public service. Private practice of law is still public service, but from private practice of law to joining the judiciary, it's like moving from the periphery to the core, to the center. This is public service plus. It involves sacrifice. It involves a lot of heartache. The private sector work is much more freedom, social freedom, as well as economic freedom. which you'll have to trade off when you join the government, in any position in government. Economically, I have suffered some loss.
Well, how will you apply this to the Supreme Court if you are appointed?
I mentioned that an economic restructuring of the incomes of the entire judiciary would be high in my priority in order to retain or attract great talent into all the echelons of the judiciary. That is my primary proposal for reform, if you call it that. Because I think I personally suffered from it, and therefore it means a lot to me. But I am not alone. There are many who feel financial insecurity in the judiciary. Maybe not in the Supreme Court, but especially in the lower echelons.
Alright, last question, please. You were a recipient of a summer program on negotiations at the Harvard Law School from the Supreme Court. What did you learn from the said program that you were able to use it in the Court of Appeals Mindanao Station?
Yes, the program was on negotiation. They have a 5-day intense program on negotiation, and I learned a lot. It was an eye-opener. I have never seen negotiation in that light, and it tells you how to be effective, how to make the parties come together. And have I applied it? Yes, I believe I have mediated more. And if you know the art of negotiation, you can actually help in the mediation of cases, especially family cases, business cases. A lot of them are ripe for mediation, and while we have a Philippine Mediation Center in Cagayan de Oro in the Court of Appeals, still the court can also help mediation if he knows the basic elements of negotiation. That was an eye-opener for me, and I learned a lot, and I believe I have applied some of it successfully, Your Honor.
How do you intend to use this learning of yours in the Supreme Court if appointed?
I do not know, but it also allows you to understand the structure of negotiations, and I think I can help evolve a mediation policy that might be more effective in the might attract more people. The essence of negotiation is it is better than going to court, better than litigation. But there are techniques to appeal to the self-interest of the parties. It's not something that should be imposed. We want you to mediate, we want you to negotiate, to come up with a compromise, but rather show them how it benefits them. And that was the essence. That it is better to negotiate than to go to court. They have developed this word, which sounds funny, BATNA. This is common for most alternative dispute resolution seminars. What is it? Better alternative, better than going to court, better than litigation. You show that. You show how much leeway there can be for the parties to compromise without compromising their principles, of course.
All right, thank you.
At all levels of... I'm sorry.
Okay. Thank you very much, and then good luck.
Thank you, Your Honor.
Thank you so much, Judge Ilaw. Good morning again, Justice.
Good morning, Your
You
Honor.
know, one of the rules of the judges requires that in determining the qualifications of candidates for nomination, their mastery of laws, rules, and jurisprudence must also be tested.
Yes.
So let's begin, Justice. International law. It is a general rule that a state cannot be sued without its consent. Of course, you are aware of the dispute between the Philippines and China on maritime area. And the Philippine government referred the case to the Permanent Court of Arbitration, or PCA. And the PCA proceeded with the proceedings without the consent of China. In fact, China refused to participate in the proceedings. But the PCA continued with the proceedings and rendered its judgment. What's your comment on this? Was China really barred? Or China, because of China's refusal, the decision can be questioned by China?
Your Honor, I am not sure if in the process of litigating the issue whether jurisdiction has been acquired over China under international law. In the International Court of Justice, for example, jurisdiction is purely voluntary on the part of the state because of the sovereign character of the sovereignty of the state. In this case, I think the rules are different because we are basing it on the law of the sea, on the Convention of the Law of the Sea. I understand that China is a signatory, and if that is so, then they are bound by the decision of the permanent arbitration panel on issues
In
that
other
involve
words,
the
Justice, what is your basis in saying so? That the PCA has acquired jurisdiction over China.
I believe if you are a signatory of the Convention of the Law of the Sea, that the panel, the arbitration council has jurisdiction over you. That's my reading.
Do you remember when the Philippines ratified UNCLOS?
I remember only that the Philippines was one of the first to ratify it because
1984.
Yes.
How about China?
I do not know.
1990. Yes, considering that China ratified the UNCLOS,
Yes.
the PCA can proceed with this arbitration proceeding.
That is my theory, Your Honor.
Does the PCA have adjudicative function?
Yes, disputes involving the Convention on the Law of the Sea, they can adjudicate disputes in
No,
this matter.
not just this. It has no adjudicative function, considering its name, PCA arbitration only.
Arbitration.
And it renders services as secretariat or registry to international tribunals or courts. It has no adjudicative function. You say it cannot even punish China.
Yes, that's true.
Okay.
It cannot
Okay.
enforce, but an arbitration, Your Honor, my understanding, I may be wrong.
It has no. It has
It's a
none.
voluntary
Yes.
yielding to a third
It has no
party who is
adjudicative-
allowed to decide.
It has no adjudicative function.
In that sense.
Only arbitration, as what you said, like mediation. Okay, next question is, you mentioned mediation before while you were interrogating by or questioning by Judge Ilaw. Do you think mediation can apply to the Supreme Court?
I think compromises are available at whatever level at whatever stage of a case, even on appeal. And in the Supreme Court, why not? I don't see any strong reason why a compromise cannot be reached at that level, Your Honor.
Justice, the Supreme Court only determines questions of law. It's too late for the parties to go up there and, lay their facts before the court. No, mediation cannot apply. That has been, when I was still there, Justice Amorfina Herrera filed with the court a memorandum recommending mediation, but it was denied, considering that only questions of law can be determined by the Supreme Court, not facts. Okay, next question
May I
is...
suggest a alternative way of looking at it? I agree with you there, but I've always understood from the rules of court that cases are compromisable even at the execution stage.
It's too late for the parties to have mediation before the court. Otherwise, if you are correct, well, that's your own opinion.
Yes.
Supreme Court, while I was still there, could have,
Compromise.
accepted or granted the recommendation of Justice Amor Herrera. Okay, how can litigants go up to the Supreme Court under the rules of court? Kindly mention the specific rules.
Only through appeal by certiorari, except in certain criminal cases, wherein the penalty is life imprisonment or
Under what rule?
Rule 45, Your Honor.
Rule?
45. Rule 45. Appeal by certiorari. petition for review on certiorari.
Criminal cases.
In criminal cases, if it is a heinous, no, I'm sorry, if the penalty is reclusion perpetua or life imprisonment, I believe by notice of appeal.
Under what rule?
Notice of appeal under Rule 41, 44. I'm sorry, 122.
45. And the caption of the petition is?
I'm sorry, Your Honor, it is a petition for review on certiorari if it is, in most cases.
Appeal. Appeal is under Rule 45.
Appeal by certiorari.
Yes. How about Rule 65?
Rule 65 is always available because the issue is jurisdiction, and therefore the Supreme Court is the highest administrative...
Not only on the issue of jurisdiction, but determining whether or not the lower courts committed grave abuse of discretion.
Amounting to lack of jurisdiction.
There is now a move in the lower house through Congressman Fariñas. In fact, that has been his long intention to abolish the Supreme Court's or the judiciary's JDF. You know, of course, we have been receiving JDF funds.
Yes, Your Honor.
Do you think Congress can do that?
I think the Constitution allows the Supreme Court, the judiciary, to source its own funding for its activities, for its development. And I think under that, it would be unconstitutional.
May I first let you know the grounds mentioned by Congressman Fariñas. Because of this JDF, the Supreme Court becomes the one who appropriates the money and the one who implements, and that therefore it is a violation of separation of powers. That is the contention of Congressman Fariñas. What's your comment on that? Can Congress abolish our JDF?
I don't think so. Your Honor,
why?
Well, first of all, JDF is a creation of law, and yes, they can repeal the law. But can
again, Justice, JDF is a creation of?
Oh, I believe it was a creation of during martial law, if I'm not mistaken. The fund was created at the time.
Presidential decree number?
Presidential decree. I don't know the number. I don't remember the number. But that is statutory.
And therefore, Congress can repeal it?
Can repeal it. But in my opinion, once it is there, Congress cannot repeal it without violating the rule against diminution of the benefits of the judiciary. It would also attack the independence of the judiciary by removing funding that has been there and has become part of the budget, sources of the budget of the judiciary. In effect, they are diminishing the benefits of the judiciary. That, I think, is contrary to the Constitution.
Congress can repeal it. It can pass a law repealing that presidential decree on JDF. But the question is, what will happen to that law when it reaches the Supreme Court?
Well, yes, I agree with you there.
That is the answer.
But I do believe that the correct argument would be that it would constitute a diminution of the benefits, which is contrary to
Mr. Justice,
the independence.
Because that is a law, Congress can repeal it any time. But the question is, do you think the Supreme Court will declare it unconstitutional? That is the correct answer. Congress can repeal any law.
Yes, I think.
Next question is...
I agree with you 100% that the Supreme Court should look at it very carefully.
What do you mean by expanded jurisdiction?
When the jurisdiction of a court is either increased or widened, the word is...
the new or 1987 Constitution. First, you can answer this question if you can define what is judicial power.
Judicial power is the power to hear and decide cases that come before a court. That is the essence of judicial power. The power to hear and decide.
That is the provision under the old Constitution. But the new Constitution, this expanded power of the courts has been added. Also, to determine whether or not any agency or instrumentality of the government has committed grave abuse of discretion or has decided cases for lack of jurisdiction. This is what we call,
Expanded jurisdiction.
in America, judicial review. Do you know the history of judicial review?
Judicial review is essentially the power to determine what the court is. I'm sorry, what the law is.
No, the history. Why that under the old constitution, this expanded power was not provided for. It only appeared, under our new constitution or under the 1987 constitution. Why is it that it is there now in our new constitution? Do you know the history, the background?
Yes, martial law.
Yes.
It's a reaction to martial law and the, how do you put I'm sorry to say, the timidity of the court to review the acts of Marcos. And under martial law, there was a general feeling that the Supreme Court was timid in checking abuses of the other departments, specifically the executive. And so this was added, but I believe that was already inherent in judicial power. This was more like emphasis is
that is
stress.
the history inherent in judicial power. But
I believe it is.
can you trace back the roots? Where did it come from? Why did we adopt it?
We can go back to the Madbury case in the United States, wherein the Supreme Court had to rule whether it had the power to review acts of the other departments, and it stated very clearly that the power of judicial review, which is now interpreted as judicial supremacy, is the power to determine what the law is. And that includes the Constitution.
No.
Even if
Justice, it's not the power what the law is that is interpretation of the law. It's the power to determine whether or not the lower courts or other agency of the government committed grave abuse of discretion.
that is inherent in the...
So, what happened to this Marbury versus Madison?
Well, in this case, I think it was Jefferson, President Jefferson questioned...
who was the president who issued first the commission or appointment of Marbury? Do you remember?
I think it was Thomas Jefferson. If I'm not mistaken, the history is murky to me.
President Adam.
Oh, sorry, Adam. And the issue was whether or not it was
He issued an appointment as Justice of the Peace in favor of Madison.
Yes.
But then after the presidential election, Jefferson sat. And Jefferson refused to issue that appointment. Do you remember the facts?
Yes.
And therefore, Marbury went up to the Supreme Court.
Yes.
The Supreme Court at that time was so confused because, you know, the Chief Justice then was Chief Justice John Marshall, and he refused to counter-attack the President or Congress. And there was no provision under the Federal Constitution granting the Supreme Court of America this power. But being the Chief Justice, and he was a very, very intelligent justice who had full of wisdom, he dared to issue this kind of decision. And it has been said that that was the defining moment of Chief Justice John Marshall.
If I may add, just a little bit.
Okay.
I also remember that is the case wherein the concept of judicial review or judicial supremacy was first introduced, and it was based on the idea that if it is the courts who determine what the law is, and that includes the Constitution, and therefore it may appear to the public.
What the law is, interpreting the law,
Including the
interpreting the
Constitution, yes.
Okay.
So they have the final say on what the law is, and that is a form of judicial supremacy.
It's not only determining what the law is, but determining whether or not the lower courts or other agencies, as what I said, committed grave abuse of discretion.
I also remember, Your Honor, correct me if I'm wrong, but this is the first time also that we talk of judicial diplomacy, because although it insisted on its power of judicial review, it actually favored the president, so it was like a win-win situation for Marshall. He was a very intelligent Chief Justice.
red light is there. Justice, Attorney Cayosa, I'd like to ask one or two more questions.
Yes.
Justice, we just received an opposition from Attorney Sabino Padilla Jr. and the rules of the JBC, the revised rules, allow us to request the applicant or the candidate to submit a comment or a response to the opposition should you wish to do so, no? To within 5 days. So we will be furnishing you a copy because I think it will be unfair to require you to respond to this opposition not having read it. So we just received Sabino Padilla, Attorney Sabino Padilla Jr. Okay, so we will just furnish you on your way out a copy of his opposition so that should you decide to submit a comment or response thereto, then you would have that opportunity before we vote on the nomination.
Okay. How will I send the...
You may just send it to us through the secretariat. Okay.
I'm leaving this evening for...
They will furnish you a copy and then you can just mail it to us. Or
just
you can
mail
just, send it through courier, private courier. That's all, Justice. Thank you.
That's all, Justice. You are excused.
Thank you. Thank you very much, Your Honor.
For the live feed. So as we wait for the next candidate, Madam Chairman, may we suggest that we take a 2-minute break to allow the live coverage to fix the audio problem.
Okay, break for 2 minutes.
Natunghayan ang pag-upo ni Justice Romulo Borja. Siya po ay 68 years old. Kanina po natanong ni Justice Maria Cayosa na ito pong si Justice Romulo Borja ay nagkakaroon lamang ng case resolution na 12 cases per month. Ayon po kay Justice Cayosa, ang resolution cases po ng isang associate justice ay minsan umaabot ng 42 hanggang 48 kaso. Kanina po ay tinanong siya kung magagawa ba niya to sakaling maupo siya bilang associate justice. Ang tugon po rito ni Justice Romulo Borja ay mahihirapan siya na gawin dito dahil maraming proseso na pinagdaraanan ang bawat kasong kanyang nire-resolba. Kabilang na rito, tinitingnan niya rin yung pwesto na kung maaari sana ay pipilitin niyang na makabuo ng ganung karami o makasolve ng ganung karaming kaso para matugunan yung normal resolution of cases sa loob ng isang buwan. At kanina natanong din siya ni Justice Cayosa tungkol doon sa pag-speed up ng mga kaso. Meron siyang ipinapanukala na bukod doon sa mapabilis yung pagresolba doon sa mga regional trial court ng bansa ay nais din niya na magkaroon ng separation. At least in that way ay mas bibilis at mas magagaan yung trabaho ng mga higher officials para mabigyan ng magandang resolusyon ang bawat kaso na ipinapasok nga sa Korte Suprema. Hiningi rin, katulad din ng mga naganap kahapon, hiningi rin yung posisyon ni Justice Romulo Borja tungkol sa pag-restore ng death penalty at maging yung dispute doon sa South China Sea. Katulad pa rin ng kanilang mga posisyon, meron kasing umiiral daw na batas para mabigyan ng sapat na tugon itong pag-aangkin nga ng ating bansa dito sa mga isyong ito. Particular dito sa dispute dispute ng ating bansa dito sa ng China doon nga sa West Philippine Sea. At nabanggit nga rin dito ni Chairman Justice Gutierrez na itong permanent court ang siya talagang dapat lapitan at tingin naman daw ni Justice Romulo Borja ay nagampanan itong tama naman daw yung ginawa ng ating bansa na lumapit sa Permanent Court of Arbitration. Samantala, sa mga oras na ito ay kasalukuyan pong naka-break lang para sa 2 minuto ang sesyon dito po sa loob ng division hearing ng Korte Suprema at inaasahan natin na bago po bumalik yung public panel interview ay susunod na sasalang naman itong si Ginang Amy Javier at si Ginoong San Pedro. Dalawa na lamang po itong natitira na aplikante para nga po sa mababakanting upuan nitong si Supreme Court Associate Justice Arturo Brion na siya pong magre-retire sa darating na December 29, 2016. Ginaganap po yan ngayong araw dito po sa Division Hearing Room ng Supreme Court Main Building. Kahapon po, na-interview na ang apat o yung 7 mga aplikante at bukod dun sa 7 ay meron pang mga kandidato doon sa posisyon na may previous interview na sa Judicial and Bar Council. So ito pong 3 na natitira o nakaschedule na interviewin ngayon ay mapapasama po doon sa 7 na in-interview kahapon at 7 na meron pang valid interviews noong mga nakaraang panahon. So inaasahan natin dito po sa 7 mga aplikante para sa posisyon na babakantihin ni Supreme Court Associate Justice Arturo Brion sa darating pong December 29 ay inaasahan na mamimili lamang po ng shortlist ang Judicial and Bar Council kasama po ang non-members at ang regular members para po sa pagtutok doon sa pagpapasa ng shortlist kay Pangulong Rodrigo Duterte. Anumang oras simula ngayon, inaasahan po natin ay muling magbabalik po itong sesyon dahil inaasahan na nga na ang susunod na uupo para ma-interview ay itong si Ginang Amy Javier kasi ito yung nasa listahan nung ibinigay sa atin ng Supreme Court. So inaasahan natin na kapag nakaupo na nga si Ginang Amy Javier, may mga particular na question din na ibibigay sa kanya at hihingin din syempre yung posisyon nung kanyang mga trabaho na ginawa noon pang mga nakaraang taon. Maidagdag ko lamang kanina ay nabanggit din ni Justice Romulo Boraha na nung matanong siya ni Justice Cayosa na tungkol doon sa kanyang mother's maiden name dahil nga tumutugon na parang ito po ay may relasyon kay dating Pangulong Duterte pero binanggit niya na nagkita lang sila nitong si Pangulong Duterte nung ito pa.
Yes, Your Honor. Okay, I know you feel so relaxed. Thank you. May we request Attorney Cayosa to start.
Thank you, Madam Chairman. Good morning, Justice Lazaro Javier.
Good morning,
Your Honor. Just for the record, we will request you to maintain that distance from the microphone. We understand that there are several who are monitoring because we are on live telecast, even on Rappler. So we have been getting requests to improve the audio of the telecast. So they will request that you maintain that distance from the microphone. Yes, anyway, you have your voice will be picked up. It's quite a powerful microphone.
Yes, Your Honor.
And we would like to thank also the public for being vigilant and in helping us through the Twitter questions. With that, may I proceed with my questions? You were recommended by retired Justice Roberto A. Abad, but only for the vacancy of Justice Brion. I'm wondering, was he not going to consider you for the vacancy of Justice Perez, which was published earlier?
He was already talking to me even before the vacancies were published in the newspaper, and he actually told me that he has been praying for me, that I would be led to where I must be. So he was hinting at recommending me for the post. I expressed some hesitation, but later I agreed. And I wouldn't really know why he recommended me only to the post of Justice Brion, though perhaps he was also giving me time to reflect on it, Your Honor.
What emboldened you to accept the recommendation of Justice Abad?
Your Honor, yesterday, if I may inform you, I just reached my age of seniority.
Yes, we noticed that.
Yes, November 16, Your Honor. And I've had 40 years of government service, 6 years as a public school teacher, 24 years as an advocate in the Office of the Solicitor General, and almost 10 years in the Court of Appeals. I've been praying, Your Honor, and I really believe that this is the moment.
Thank you, Justice. Now, in your PDS, you also stated that you were once a bar examiner for political law in
Yes, Your
2011.
Honor.
I would just like to know, what are your views with respect to reverting back to essay-type questions in the bar as compared to having multiple choice questions as was in the two previous bar examinations? Do you feel that we are ready to shift to MCQ, or should we continue having the essay questions? And what would be an effective way to determine the preparedness of a law student to join the legal profession?
You know, Your Honor, when Justice Abad introduced the MCQ, it was not easy. He introduced us to the scientific method of preparing questions. Not everyone can just prepare MCQ questions. To be effective, the MCQ questions should have a certain combination, like 20% recall, 40% application, and 40% comprehension. And the length of the problems must also be taken care of because we avoid the giveaway choices. And the reach is very, very broad. You can actually accurately gauge how much the students know about the subject. So not everyone, it takes a lot of training to do that, Your Honor. We were trained around 6 months, and the training was by stages. It cannot be just one sitting. We had a lot of drill, Your Honor, and it was actually a lot of time and a lot of effort. But then, I believe in that system, Your Honor, provided the questions are crafted scientifically and the combination is also scientific, because the MCQs have been used all over the world. I think when it was introduced by Justice Abad, we were informed that it was only us who was not using it, along with Brazil, I think. And so he tried it. I believe in it. I accepted the assignment, although it was so difficult for me to draft a single question. It took me an hour to draft a single question and to think it was just a recall question. But when it came to comprehension and understanding, it took me 2 hours to prepare each question, because the question should be very simple, direct to the point, and fair to the students. But then, I think it's a balance what he did, because there was a portion, I think it's 40%, where the students were asked to prepare, draft a legal opinion and a memorandum. So from there, we were able to gauge exactly the capability of the student to reason out, to write, to apply logic. And we also studied and realized that those who passed the MCQ test were the same ones who passed the essay. So there was really compatibility and there was consistency.
You continue to teach.
Yes, Your Honor.
And do you think that the current curriculum, law curriculum, is an effective way of preparing our law students for the practice of law.
Yes, Your Honor, except that I really believe that the curriculum should be standard and the law schools should be given a syllabus for each subject so that it will be uniform and the students do not have to rely on the patience, the understanding, and the output of the professors. They become self-reliant and they push themselves far best so that they will do learning their way and they're experiencing it personally.
Thank you, Justice. Now, moving on to another topic. You once served the Office of the Solicitor General as an Assistant Solicitor General, is it not?
Yes, Your Honor.
And several instances when we conducted interviews, one of the reasons for the delay in the appellate courts were actually postponements requested by the sometimes the ASG or some of the solicitors. Now, do you think that this is still true, it still holds true, that they still request for an extension of time to file the required pleadings? And how do you address this if, as an appellate court justice?
Your Honor, when I was Assistant Solicitor General, I really believed that it was just a question of time management. And I was trained, and many of us were actually trained, beginning with former Solicitor General Estelito Mendoza, and then followed by Solicitor General Frank Chavez. We were trained to comply with deadlines. And if we didn't comply with the deadlines, our salaries will get suspended, sometimes even forfeited. So, because I wanted OSG so much to be my career, I adapted to the discipline of OSG, Your Honor. And when I became Assistant Solicitor General, no court of law could ever attribute to my team delay because I imposed on my lawyers that we should serve speedy justice. And now, as appellate court associate justice, I also impose the same on OSG because I know I stayed there for 24 years. It's very doable, especially now that I think OSG's number has doubled or tripled ever since I left it, Your Honor.
Okay. I have the warning light there, so this is my last question. In 2012, you penned a decision in a case involving the extradition of a Filipino priest accused of sexual molestation in the U.S. In your decision, you stated, and I quote, "Suppression of crimes is a concern not only of the state where it is committed, but also of any other state to which the criminal may have escaped." End of quote. In the Philippines, this holds true. It is not too difficult for our neighboring countries to request for extradition. But do you think that we enjoy the same benefit now when, especially with respect to the U.S., should we need to extradite a foreign national to face our courts?
Yes, Your Honor. I think the U.S. is quite cooperative. When I was in the OSG, I handled a number of extradition cases.
How do you think we should be, we can be more effective in extradition cases, considering that like it can involve courts from all levels?
Your Honor, there must be cooperation, there must be consistency in our actions. We have to be prompt also in the preparation of our petitions, and it requires close coordination. So, from my experience, Your Honor, as Assistant Solicitor General, I didn't really have any problem. And I should also want to commend the Department of Justice. The Department of Justice was very, very efficient at that time. Whenever we received extradition requests, we promptly acted on them, Your Honor.
As I mentioned, that was my last question. Justice Javier, good luck. Thank you.
Thank you, Your Honor.
Thank you, Madam Chair.
Thank you so much, Attorney Cayosa. May we request Judge Ilaw to continue? Judge, Attorney Miguel muna.
Yeah. Thank you, Madam Chair, and good morning, Justice Lazaro Javier.
Good morning, Your Honor.
In his letter recommending you or endorsing you, your application, Justice Abad said, and if I may quote, Justice Javier is amply prepared to tackle the difficult job of an Associate Justice of the Supreme Court. No? What aspect of the work of a Supreme Court Justice do you think would you find difficult?
Your Honor, for one who loves the practice of law, who has passion and love for the practice of law, the highest fulfillment is the Supreme Court. And in the Supreme Court, that is the final arbiter of all cases. We cannot afford to err. That is the challenge, Your Honor. We have to double, if not triple, all our effort, all our industry, and we have to be very keen about serving justice because the people have nowhere to go further.
What to your mind is needed to improve the moral fiber of the legal profession?
Your Honor, that should be taught early on in law school. And every lawyer, every judge has the obligation, the duty to be a role model to our young minds and the lawyers to be our young lawyers, Your Honor. Because it is only by seeing us as good examples that they will follow suit. And so I also believe that we have to be very strict in implementing our own code of conduct. We have to be very strict about the demeanor of every member of the judiciary, Your Honor. And everyone should realize that the most demanding of all is the profession of law, Your Honor.
I read from your personal data sheet that your husband is a lawyer and a private practitioner. And I also know of other members of the bench whose spouses, respective spouses, are private practitioners. I just want to know how you deal with such a situation, particularly in insulating yourself from the influence of the spouse, for example, in dealing with your work.
Your Honor, I married my husband because we shared and continue to share the same values of honesty, integrity, faith, and love for family. So I can say with conviction and honesty, but that my husband has never ever tried to influence me. He is the one who is shielding me.
Thank you. Let me now go to the tweeted questions. One or two from the tweeted questions. How do you view the credibility of the current Supreme Court?
Your Honor, the current Supreme Court may have rendered decisions that did not sit well with the perception of some regarding what must have been a just decision. But that should not diminish the credibility of the Supreme Court as an institution, Your Honor. After all, the Supreme Court has only one standard, that is to apply the rule of law.
Another tweeted question, and this may be my final question, is what is your personal opinion or personal stand on the issue of the Marcos burial?
Your Honor, I do not agree with the majority opinion of the Supreme Court. I think the conviction made by the people themselves is the highest conviction of all on earth. And no further conviction from any other inferior court, even the Supreme Court, can ever trivialize that conviction, Your Honor. And it lasts forever and ever, even beyond life, until and unless another people power can restore the person to his previous post or situation, because he was convicted by people power, which is the highest form of conviction. No other court can ever reverse that or can ever wash it off, except people power itself also. That's my view, Your Honor.
Coming from a constitutional expert, I agree to that answer, and thank you and good luck, Justice Aviat. Thank you, Madam Chair.
Thank you, Your Honor.
Thank you, Attorney Mejia. May we request now Judge Ilaw?
Thank you. Thank you, Justice Gutierrez. Good morning, Justice.
Good morning, Your Honor.
Today is your birthday.
Yesterday, Your Honor.
Yesterday. Belated happy birthday.
Thank you, Your
And
Honor.
this is my gift for you. You mentioned about seniority. You're now a member of the senior citizen.
Yes, I'm a dual citizen, Your Honor.
So you're going to avail all the discounts given by the government.
That is my plan, Your Honor.
At any rate, as a member of the academy and consistent honor student since high school, you have not pursued postgraduate studies after your law degree. Why?
Your Honor, I did not pursue postgraduate because I believe that giving back, I am more needed by the students of law, Your Honor. So my hands are so full teaching students of law. And even the postgraduate in pamantasan ng lungsod ng Maynila, Your Honor. Because teaching has always been my passion, Your Honor. And I believe that each one of us should impart knowledge. That is our duty in order to continue the tradition of excellence.
All right. Again, as a senior citizen, that you're aware that first level or lower courts are receiving allowances from the local government units.
Yes, Your Honor.
Do you agree with the bill pending in the House of Representatives aimed at removing the allowances of the said members of the judiciary from the local government units?
I agree with that, Your Honor, provided the Supreme Court will give them a substitute allowance. They need it, Your Honor, and it's in the law.
Who needs it? Supreme Court?
No,
Members
Your
of the
Honor,
Supreme Court?
maybe not Supreme Court, maybe the lower court judges, Your Honor.
You attended a summer course on civil and commercial laws at Harvard University. What did you learn from such courses that you were able to apply it to the Court of Appeals?
Your Honor, I attended that when I was still Assistant Solicitor General. So, yes, I just discovered that Harvard also taught the same commercial and civil law as what is taught in our universities, Your Honor, because many of our provisions are also patterned after American laws.
And do you think you can apply the same to the Supreme Court if you are appointed as an Associate Justice?
Yes, Your Honor, the totality of my knowledge, Your Honor, and my experience.
As a member of the Academy for 33 years, a bar examiner and a bar reviewer, what changes do you think need to be effected in the bar examinations as to help aspiring lawyers to become a lawyer?
The bar examination should be reasonable, Your Honor. They should be limited to the basics. And there must be no unreasonable or unfair questions that are not relevant to what the students would need, the first year lawyer would need in his first practice of law.
Do you mean to say that previous bar examiners are not reasonable?
Yes, Your Honor.
You have 354 decisions appealed or pending appeal. Do you think this number reflects the quality of the decisions you promulgate?
Yes, Your Honor, because 98% has been sustained by this court, and I was only reversed by 1.9%, Your Honor.
You rose from the ranks beginning as a solicitor at the Office of the Solicitor General. Records show that you had not gained any experience in the private practice. Do you think this is a disadvantage to you? Should you be appointed as a member of the Supreme Court?
No, Your Honor.
Why?
Because in the Supreme Court, there must be, the requirement really is practice of law as a judge, at least 15 years. I have been trained to have a judicial mind, Your Honor. I have been trained in the field of constitutional law, and in the OSG, 80% of every volume of the SCRA was handled by the Office of the Solicitor General. So I really believe that the career path that I took was is very relevant to the practice of law as Associate Justice of the Supreme Court.
So why do you correlate private practice as a practice in the government, following the doctrine in the Monsoon case?
The private practice is a noble practice, Your Honor. But when one goes up as a magistrate, especially as a Supreme Court Associate Justice, you do not think anymore as a practitioner. You think as a jurist, one who decides cases.
What were your inputs while serving as a member of the Supreme Court Subcommittee on Revision of Rules of Civil Procedure?
Your Honor, I led the revision on special civil actions. And we've actually finished the revisions, and we submitted them to the Supreme Court, Your Honor.
But when was this, please?
This was in, I think, 2013.
All right, thank you. No further questions, and good luck, and happy birthday again, please.
Thank you, Your Honor.
Thank you so much, Judge Ilaw. Belated happy birthday also, Justice.
Yes,
So you
Justice,
are
thank you
now
po.
a member of our society.
Yes, Your Honor, and
Senior
proudly a member.
Okay. Of course, you know that sometimes I ask legal questions.
Yes, Your Honor.
Questions on, for example, international law, domestic laws, etc. Anyway, very easy. What is your concept of inquiry in aid of legislation?
Your Honor, inquiry in aid of legislation is the very essence of the legislature's function as a lawmaking body. Without it, the legislature will be paralyzed, just like what happened when the former president, issued 464. There were months that the processes served, the invitations served by the legislature were all snubbed. That's why the Congress, the Senate specifically, was forced to go up and question the issue of 464, Your Honor. And the Supreme Court rendered a very informative ponencia on what executive privilege means and how it complements or it must be treated vis-a-vis inquiry in aid of legislation, Your Honor.
Let us visit this Blue Ribbon Committee of the Senate. Of course, it invites resource persons, to aid the senators in crafting the necessary bills or laws. But you will also agree with me that sometimes the senators are abusive. They are not courteous, even if the Constitution says that the rights of those resource persons should be respected.
Yes, Your Honor.
Sometimes they even scold people appearing there, and that was the reason why the former Vice President Binay refused to appear. But why is it that there has been no complaint whatsoever from any sector of our society with respect to this kind of proceeding, which is highly irregular sometimes?
Yes, Your Honor. I agree fully, Your Honor. I was in the OSG when 464 was issued, and I believe that 464 was issued precisely in reaction to the hostile attitude of the Senate in handling the resource persons. The executive then believed that these people from the executive who were invited to appear before the Senate deserved to be respected also. And it was far from that how the Senate was treating the members of the executive, Your Honor. So I think several meetings were held between the executive and the legislature in order to avoid an impasse or a constitutional crisis, because when the executive no longer appears before the Senate has nothing more to do, and there will be constitutional crisis. And I think, Your Honor, they came up with some rules, the Senate, regarding how to fairly treat their witnesses or resource persons, like they will be informed beforehand of the legislation that is intended, and they would be informed also of the possible questions that will be asked.
Thank you, Madam Justice. But, even in America, that is being done, how they grilled all those people appearing before the Senate. But the reason is we allow this kind of proceeding, even if it is highly irregular, for the information of the public. That is the basic reason. Anyway, so how does an inquiry of aid of legislation differ from question hour?
Your Honor, question hour is also found in the provision under the legislature, and it's all about exercising the oversight function of the Senate or the Congress, wherein Congress may ask questions, or the members, department heads may voluntarily appear, or may seek permission, with the permission of the President, to apprise the Congress on how they are implementing the laws that have been enacted by Congress, Your Honor.
That is correct. And so we now will move on to executive privilege, because this is really connected or relevant to the previous questions I asked. What is your concept, Justice, of executive privilege? And that was the reason why some cabinet members refused to appear before the Senate Blue Ribbon Committee, and it was justified.
Yes, Your Honor. The executive privilege is the privilege of the executive to withhold information from the court or from Congress of some information that are classified as either constituting the conversation of the President with his close advisors, military secrets, diplomatic negotiations, Your Honor, and those matters that were taken up in closed-door meetings with the President and his cabinet, and the instructions of the President to his department heads, and also those matters that involve national security, Your Honor.
Yeah, that is the most important, national security on the part of especially cabinet members, armed forces of the Philippines, especially the officers such as the generals. They cannot appear before, or even if they appear, they should invoke executive
Yes, Your
privilege.
Honor.
Okay. Justice, there has been extrajudicial killing anywhere in our country now. Do you think that is a crime against humanity?
Your Honor, crimes against humanity actually include extrajudicial killings, but only if they are perpetrated with deliberate intention and directed against a specific group or population that is widespread and systematic in nature, Your Honor. And yes, Your Honor, civilian population.
Killings is tantamount to crime against humanity? Is it widespread? Is it a part of a systematic plan
To warrant, Your
to
Honor,
attack,
yes,
to attack civilian population?
to warrant
To warrant
the
that it
cognizance
should
of
fall under crime against humanity,
yes,
within
to warrant the
jurisdiction of
exercise,
ICC?
to warrant, Your Honor, the exercise of jurisdiction by ICC.
Crime against humanity?
Your Honor, there are requisites before the ICC can take judicial cognizance.
Whether or not this extrajudicial killing is a crime against humanity.
Extrajudicial killing, if it is widespread and systematic, the direct attack on the civilian population or a group. Yes, Your Honor.
So that falls under the jurisdiction of the ICC?
Only if the party
Is a-
state,
so in your own opinion, that is a crime against humanity. It is an attack against civilian population.
Your
Who
Honor,
composed the civilian population? The drug lords, drug pushers, suspects of people engaged in drug menace. So you mean this constitutes civilian population?
are we talking now of what is happening in our country, Your Honor. Your Honor, if the killing or killings are directed against the civilian population, and these killings will not qualify as justifiable killings, like the person killed was not committing a crime, or was not or posing danger to the lives of the arresting officers, I would say that there is a need, Your Honor, to identify which deaths are justified because there was aggression also, there was danger posed on the life of the arresting police officer on one hand, and those that were not within the justified killings on the other, Your Honor.
Extrajudicial killing has become nationwide. So, can you consider this as an attack against civilian population? Yes or no? In your opinion,
Your Honor,
only.
yes, Your Honor. This is just an academic discussion.
Academic.
Anyway, thank you, Your Honor, for allowing me to also present my opinion on this. I think there is a need to determine which killings are justified.
No, at this point, we cannot determine anymore. We cannot determine anymore. Maybe it can be determined when it's already before the tribunal concerned, which has jurisdiction.
No.
But at present, we cannot determine anymore. The killing has become so widespread.
Well, in that case, Your
we
Honor,
cannot determine any more justice at this point. So, do you believe it is already a crime against humanity?
only if, Your Honor, the Philippines, the government specifically refuses or is unable to do it itself.
That is whether or not ICC has jurisdiction.
Yes, Your Honor.
In your opinion, is this not a crime against humanity at this stage? As you look at it,
No, Your Honor. No.
how about, is it a crime constituting genocide?
Not yet, Your Honor.
Why?
It's not as widespread or systematic, Your Honor. Not yet.
It's part of a widespread or systematic
Your Honor, I
plan,
think
group of what?
group
Ethnical group, religious group, racial group. But the group concerned here constitutes people suspected of using illegal drugs, drug lords, etc. Is this not a group?
it is
So
a
you
group.
can classify extrajudicial killing as genocide.
It is a
It
group.
is a group.
But how big is the group?
3,000 plus.
Yes, Your Honor. If we speak of genocide or widespread, systematic, direct attack, we're not just speaking of thousands, I think. We must be speaking of hundreds of thousands, Your Honor.
So you are after the number, not after the group. Anyway,
Yes,
you
Your
have
Honor, because it's widespread.
Can the ICC acquire jurisdiction, if ever?
Your Honor, first of all, there must be a clear showing that the Philippine government is unable or unwilling to make the investigation.
At present, do you think the government is unable or unwilling?
It is not unable, it is not unwilling. I just would like to believe what General Bato has testified on during the Senate hearing, that all these unjustified killings, even perpetrated by the police officers, are under investigation by the NAPOLCOM, Your Honor.
Do you know, Justice, if there has been investigation involving the killings consisting of more than 3,000 people?
No, Your Honor.
No.
I just
So do you think the government is unable?
No, Your Honor. No, Your Honor. I do not have sufficient knowledge to conclude that the government is unable or unwilling. Because I just want to give credence to the statement of General Bato that he is actually having these killings investigated, Your Honor.
Say that there should be due process.
Yes, Your Honor.
Okay, so
Yes, Your Honor.
the last question. In the event that our government is unwilling or refuses to take action on these extrajudicial killings, and supposing we designate these killings as genocide or crime against humanity over which the ICC has jurisdiction, how can that ICC acquire jurisdiction now?
The ICC can acquire jurisdiction in several ways, Your Honor. One is when the Security Council, motu proprio, the police of the ICC can, the prosecutor rather.
I leave you at that, Justice, because the red light is there. So thank you very much.
Thank
and
you,
happy
Justice.
birthday again.
Thank you. Thank you, Your Honors.
The last candidate to be interviewed this morning, Your Honors, is Attorney Joseph P. San Pedro, individual law practitioner and faculty member, Ateneo Law School.
Good morning. Please
Attorney
take your
San
seat.
Pedro.
Thank you, ma'am.
We'll do this very fast. May I request Attorney Cayosa to start?
Thank you, Madam Chairman. Good morning. Still good morning, Attorney San Pedro. We noted that this is your first application with the JBC.
Yes, ma'am.
Okay. What made you decide to apply this time, and why the Supreme Court?
Well, I think professionally, I think I achieved already what I need. I have provided for my family. I had enough blessings from the practice of law, and my children they have a secure and good education. So I think it's time for me to give back what I have received from the practice of law. This is the time for me to pay forward the many blessings that I received as a law practitioner. And why the Supreme Court? Because I think the Supreme Court is to be allowed or be given an honor to serve as a member of the High Court, who will help me, will allow me to help in the realization of the mandate of the Constitution on the efficient and proper dispensation of justice. Yes.
Thank you. Now, I noted that you have excellent academic credentials. You graduated salutatorian at the Ateneo Law School, and you were a bar top-notcher. You have received your Master's of Law from Harvard. But I noted also that you have not had any experience in government service. Is that right?
Yes, Your Honor.
So, what makes you feel that you are prepared for a government office and a position in the highest court of the land?
I think my training and experience as a lawyer is diverse. enough to allow me to have the necessary skills and resources to contribute my abilities to the High Court. I worked before in a law firm and handled different fields of practices. I also worked as an in-house counsel, and I also served as the head of a self-regulatory organization of the Philippine Stock Exchange. In such a position, I decided cases involving trading participants of the Philippine Stock Exchange, somehow similar to the discharge of judicial functions in that respect.
Incidentally, you did not state in your personal data sheet what was your major in your undergraduate course.
EB Social Sciences.
Social Sciences. So that explains why you were a part-time faculty member in the Behavioral Science Department of La Salle.
Yes.
Yeah. Now, I also noted that in your personal data sheet, you stated that in your first 10 years of law practice, your focus was on pleading and appellate practice.
Yes.
Does it mean that you don't anymore
I did not do trial work.
litigate at this
yes,
time? So what is the focus of your law practice?
More of in a team in the law firm, I would be handling research, preparation of pleadings, documentation, basically. I did not do court appearances.
What experience do you have in court management, docket management?
Well, as I said, when I headed the market regulation department of the stock exchange, basically some form of a mini arbitral tribunal, and we handled different cases filed before that department. Yes.
I read in an article that you resigned from the PSE on October 1, 2009. Under what circumstances was that resignation?
Actually, that's not accurate. It's by mutual agreement. I took the job seriously, so I discharged the function as a regulator, and it did not sit well within certain quarters. So I had an agreement with the president, and my contract was bought out. Because there's a clause in my contract saying that we can agree and they just pay a certain sum.
So when you say your term or your appointment...
I had a guaranteed term of contract of, I think, 3 years. So when they decide to cut short, they just had to compensate me for the remainder of the term.
What did that experience teach you?
Well, I think it proved that, that you have to hold on to your principles. I am just discharging my responsibilities as mandated by my contract and agreement with the stock exchange. So, and I won't be true to myself if I will accommodate requests so I could stay on the job. I'd rather that we part ways amicably. Anyway, I consider it's just to pay the mortgage. It's a job.
Thank you, Attorney San Pedro. Now, moving on to another topic. The Supreme Court exercises supervision over the members of the legal profession, and likewise with all judges and court personnel. If you are appointed to the Supreme Court, what would you propose to expedite the resolution of the deluge of drugs cases that have been recently filed?
Well, I think it's not just the drug cases. I think there are a number of processes that we can simplify. This from my experience before when writing pleadings. There are so many formal requirements that could have been simplified if we just entrust the lawyer the obligation of being the gatekeeper, making sure that anything going to the court, they're correct, verified, and ready for trial. Because most of the pleadings, you have this verification for non-forum shopping, then the verification by the client, and certain verification of material dates. These are matters that the lawyer could have established beforehand. And so we put more responsibility on the lawyer to make sure that when we have cases before the court, there will be, they should be ready for immediate trial after the exchange of pleadings.
Do you think our rules allow for the discipline of lawyers who file frivolous cases?
I believe so. As a lawyer, we have an obligation to maintain the integrity of the judicial process. If we are part of the maneuvers to delay the dispensation of justice, it will be a disservice not just to the profession but to the country as well.
Your clearance shows that you've never been filed a disbarment charge.
Yes.
Have you actually handled a disbarment case?
No.
So you are not aware of the rules involving the disbarment of lawyers?
No.
So you cannot comment on whether or not it is wise for the Supreme Court to limit to the IBP jurisdiction of only just the private practitioners, excluding now government lawyers from its duty to conduct investigation, to report, and to recommend.
I will not be in a position to say so. I have to understand the problem.
Have you handled an administrative case against a judge in the Supreme Court?
Never.
So you are not familiar likewise with the processes with respect to administrative cases against court personnel and judges?
No, I just read some decisions.
Okay. Have you read the Code of Judicial Conduct?
Yes.
Okay, so what about the code strikes you the most?
But I think integrity and competence, because integrity somehow covers the other requirements of a judge. Independence, if you have integrity, you're supposed to be independent. Integrity, you follow the law, you're impartial. So that strikes me as the most important quality of a judge. In fact, a person, every person, integrity. Yeah.
I see the warning sign and ultimately the red light, which signals that this will be my last question. There are other applicants for the positions that actually you are here to be considered only for the position that will be vacated by Justice Brion.
Yes, Your Honor.
And there are others who are also being considered for this position. You are not the only bar top-notcher. You are not the youngest. And the others have already had extensive experience in the judiciary, being appellate court judges, or justices rather. What would you consider as your advantage, or what would you tell us to convince us that in the ranking of all the candidates, you deserve to be among the top, to be considered vis-a-vis the other applicants or the others to be considered?
Well, I'd say my comprehensive private practice, including my 20 years of teaching at the law school, as well as my dedication to the profession. I think these are the qualities that I can offer the judiciary.
With that, I thank you, Attorney San Pedro, and good luck.
Thank you, ma'am.
Thank you, Madam Justice.
Thank you so much, Attorney Cayosa. May I request Attorney Mejia?
Thank you, Madam Chair. Good morning, Attorney San Pedro.
Good morning, sir.
Or Professor San Pedro. As a professor of law, Attorney San Pedro, what can you say about the quality of legal education in our country?
Well, at least I've been exposed only to two schools. I think there is a need to impose a stricter standard on the education of lawyers. That the screening process should not start only with the bar. It should start at the law school level. That we have to exact the highest standards of our students, knowledge of law and practical knowledge of law. Yeah, so my sense is there's a lot, we should do a lot more to make sure that students have a better grasp of the workings of the law.
Do you think the present law curriculum amply prepares law students for the bench, so for the judiciary?
Well, I think the thrust of the curriculum right now is really just for getting past the bar exam. That's how I observe it. And whenever a certain school ventures into more practical subjects, there will be an effect on the performance of the students. So I'd say, but I'm more for exposing the students to the practical side of the law during law school. Yeah.
Should you be appointed as an associate of the Justice of the Supreme Court, which are you more inclined to adhere to? Judicial activism or judicial restraint?
Well, my philosophy is that we just have to stick with what the Constitution mandates, what the law mandates. The judiciary does not create policy unless we can somehow find it in the Constitution or some legal provision. Because the moment we deviate, this is what my observation in certain cases, the moment there is a deviation from rules, there will be no predictability on how the law will work in actuality. I've seen this in practice. There are decisions that is not consistent with what should be as per law or the constitutional provision.
I will be reading now from the list of tweeted questions. What measures can you propose to enhance judicial independence?
Well, I think we just have to enforce the canons of judicial ethics. They're there. The moment we adhere to them strictly, then we can be independent. Judiciary will be independent.
Do you agree with the constitutional provision that the President shall appoint justices and judges of lower courts? Why or why not?
Well, first, I view the Constitution as an expression of the sovereign will. If that's the decision of the people, we abide by it. That's my belief. Whatever the bargain the people have, we have to abide by it. But if I will, my personal view, I think the structure right now somehow checks the appointing prerogative of the president. I see it works well. It's not an exclusive executive. It's not an exclusive executive determination. There is another check right now, the Judicial and Bar Council.
For my final question, and this another tweeted question, what is your view or personal view on the Marcos burial issue?
Well, I understand there's still a motion for reconsideration, but setting that aside, I think the dissenting opinions propounded compelling arguments for the denial or for a decision that denying the burial of the late dictator in libingan ng mga bayani. There were citations of certain laws, but I think the primary issue there is we have to understand the historical underpinning of our 1987 Constitution. Where did we come from? We came from the ouster of a dictator, and to allow the dictator to be buried and given some kind of honor will be a disrespect and dishonor to the people who made sacrifices to have our democracy right now.
Thank you and good luck, Attorney San Pedro.
Thank you, sir.
And thank you, Madam Chair.
Thank you so much, Attorney Mejia. May we request now Judge Stila.
Thank you. Thank you, Justice Gutierrez and Aret Pañero, Tony San Pedro.
Good morning, sir.
Am I correct to say that the reason why you choose to become an Associate Justice of the Supreme Court is to pay back from your lucrative practice, having gained material things?
Yeah, I think, Your Honor, not just material things. I've enjoyed my practice. This one I tell my students. My practice comprises of two things. One is the profession, the one for the earning, that's the practice, and one is the vocation, that's my teaching. And I have already achieved my personal goals as a lawyer, both on the professional side and the vocation side. And that's why at this point, I think I'm all set. I can give more time to service to society now.
Will it be more lucrative to become an Associate Justice in the Supreme Court?
I think it's
Of gaining much
it
wealth?
will be a financial setback to be an associate justice, but I'm used to simple living. I came from a very modest family. My father was an employee, my mother, housewife, dabbled into jobs to make ends meet. Where I am right now is pure talent and hard work and discipline.
And surely your practice is behind the desk. You have not appeared for being a trial lawyer, a litigation lawyer.
Yes, Your Honor. It's a decision I think I made early on that I want to focus on a certain field of law, but as part of a law firm, I also handle litigation, but on that pleading aspect only.
Being a good pleader.
I'd like to believe I am.
Having an entirely private practice service record, admittedly, you do not have an experience at all in the judiciary.
Yes.
Especially adjudicating cases, which will be the one of the main tasks of the Supreme Court. Do you think you could successfully carry out said task without any experience therein?
No, I think I mentioned earlier that when I work as part of the self-regulatory organization of the Philippine Stock Exchange, I did do adjudication of cases, complaints involving trading participants of the stock exchange. So my in that respect, I have experience on adjudication.
Can you cite instances in your private practice wherein you were able to exhibit the requirements of competence, integrity, probity, and independence?
I think the most recent example would be when I was with the stock exchange, there were a number of failed brokerage companies. And these brokerage companies, they held assets of clients. So in my effort to make sure that the claimants of these assets are retained, I ensured the efficient disposition of the claims, the validation of the claims, as well as the distribution of the proceeds. So I did it in 1.5 years, These cases were lagging when I came in, and I made sure that the proper claims of the clients of the brokerage firms were returned to them as mandated by law and the PSE rules.
Do you mean to say that said change was effected during your leadership of the Market Regulation Division of the Philippine Stock Exchange?
I'd like to believe so, Your Honor.
This was not ever been done before?
When I came in, there were no distributions of assets to pay the claims of customers of these closed brokerage companies.
And what was your alleged legacy that in the said office that you could be useful to the Supreme Court?
Well,
Business
as
matters?
I think it's the independence and integrity. I could not be influenced to decide one way or the other. I just decide based on the facts before me. In fact, this one I even follow in my teaching. Never did I allow anyone to get a passing grade because somebody talked to me.
Like going back to your alleged competence, integrity, probity, independence, who could attest to these instances?
Well, I made a number of references. I have, I gave officers of the stock exchange, I gave members of the judiciary who know me, and colleagues in the legal profession.
Your records show that you obtained your LLM degree from the esteemed Harvard Law School. What important lessons did you learn while obtaining your degree that you think you could use in the Supreme Court if you are appointed as a member there?
I think what I learned there is just an expansion of my perspective and view as a lawyer. It's the exposure to views of lawyers from other jurisdictions or views from other fields of practice. So I think somehow it broadens the perspective in approaching legal issues and problems.
Do you think that such degree is indispensable in the practice of law, especially for a member in the Supreme Court?
Well, it's an added experience and training, but I think our requirement only is to be a lawyer. So it's enough that we have an educational law degree and we pass the bar and fulfill the requirements of the Constitution.
What can be the realistic view?
I think I'd stick to the requirements of the Constitution. I'd like to believe that the provision of the Constitution aims to make democratic the appointment of members of the judiciary.
So why not choose the profession of being a legislator and not as a member of the Supreme Court?
Well, as I said, it's more of the efficient, personally, I always look at the efficient employment or deployment of abilities. I think I can best contribute my abilities in the judiciary.
What will be the real time?
What do you mean, sir, real time?
Where this technology in real time? Real time, realistic, practical view?
Again,
what will be the real time?
The real time for
when?
To be a
part. As your alleged advocacy. Becoming a member of the Supreme Court.
Well, as a member of the Supreme Court, we get to shape the dispensation of justice and the correct application of the law. So I think that's coupled with my skills. I think that's where I can best serve in society, in the judicial department.
Did you mention about the strict enforcement of the law or the real enforcement of the law?
I think what I said was we have to be true and faithful to what the Constitution or the law mandates. We do not expand what's not in the Constitution or what's not in the law, because that gets us into trouble. Meaning we have a bargain, the Constitution. This is our primary rule. We abide by it. We don't deviate from the rule. Otherwise, it will be unpredictable for all of us, not just for lawyers, judges, but for the entire country.
All right, my time is up. Thank you very much, Panyero.
Thank you, sir.
Good luck.
Thank you, sir.
So thank you so much, Judge Ilaw, and good morning again, Panyero. First question is, why did you not wear your necktie so that you will appear as magistrate
Your Honor,
before the
I have
JBC?
an explanation. Actually, I have a necktie. I got the wrong shirt. It won't close. It won't close. That's why. That's the reason. I have a necktie actually, but it won't.
You have the necktie. You should have worn it before.
No, I mean the collar of my shirt won't close. It's ill-fitting right now. Yeah.
Did you not prepare your attire last night?
I think I got the wrong shirt.
It is a very important event in your career.
I know, Your Honor. No disrespect, Your Honor. It's got the wrong size of shirt.
And maybe you are excused. Panyero, you are very young, only 50. You know, once you get nominated and appointed to the Supreme Court, you will be like a monk in a seminary. And you will not enjoy what young people like you are enjoying outside this world. Are you aware of that?
Yes, Your Honor. In fact, that's my lifestyle. I'm a very private person. I don't have much I do not do much socializing. It's just work, home, school. I have very limited circle of friends in recent
I
years.
think that is not a very, very dry kind of life.
It's a deliberate choice, Your Honor, because I have certain things that are important.
You should have entered the priesthood.
I wish I could, but no. But I think it suits me. So if you're talking about the lifestyle of required of a member of the judiciary, I think I'll readily fit into that mold. If I didn't have a family, I'd say my life is monastic. But of course, I don't take it as I also enjoy certain things in life. I go to the gym, I watch movies, but simple things.
How many girlfriends did you have before?
My wife.
One woman. Okay, next question. You have no litigation experience, but you have a very, very impressive academic credential. But you know, being a member of the Supreme Court requires experience. Have you argued before the Supreme Court?
No, Your Honor. I've got the same. No.
So, maybe, anyway, I will ask you one question. This is a follow-up question to your answer to the question of Judge Ilaw. You said we don't have to expand the laws or the Constitution. Have you read the decision of the Supreme Court in the case of Senator Enrile? The Supreme Court expanded the provision of the Constitution. Okay, your comment on that decision.
Actually, there's another case too that I thought the Supreme Court would revisit to be true to the provision of the Constitution. But then for the case of Enrile, That's what I said when there's a decision that provides a basis that is not found.
The decision is not found in the Constitution. I need
or
your
some
comment.
law.
Your comment on.
Yes. Then it's a free for all. What do we do next now? It will be an arbitrary decision. Somebody applies and we just say humanitarian ground. Another person applies humanitarian ground. Then we are not following.
So
the
you
mandate of
dissent.
people. Yes, Your Honor.
Very good. John, last question. Can Congress abolish the JBC and go back to the Commission on Appointments for purposes of nomination of the members of the judiciary?
They have to change the Constitution. It's the constitutional mandate. As I said, this is what's big for me. If that's what the people approve, we follow. We don't tinker with what the people mandated us. This is our bargain.
So I think, you should be at least 60 before you go to the Supreme Court. You are very young. I have some more litigation experience, huh? Okay, good luck.
He's the last candidate for this morning, Your Honor.
Okay. The public interview is now adjourned.
At dyan na po ang pinakahuling pangyayari na naganap ngayon dito sa loob po ng division hearing ng Korte Suprema, kung saan nga po ginanap ng Judicial and Bar Council ang public panel interview para po doon sa tatlong natitirang aplikante para po upuan itong babakantihing posisyon ni Supreme Court Associate Justice Arturo Brion. Ito pong tatlong ito ay sina CA Justice Romulo Borja, isang 68 taong gulang. Kasama rin po si Justice Ami Lazaro Javier, 60 years old naman po siya. At yung pinakahuling interview ay itong si Attorney Joseph San Pedro. Kanina po doon sa nangyari dito sa pag-i-interview kay Ginoong o kay CA Justice Romulo Borja, naging tanong nga po rito ay yung pagresolba ng case resolution dahil 42 yung minimum average na nire-resolba ng isang associate justice. At doon po sa record niya ay kaya niya lamang makaresolba ng 12 kaso. Binigay niya rin yung kanyang posisyon doon sa pagpapabilis ng pagresolba ng mga drug cases at siya rin po ay merong pending case dito po sa pangyayari po sa Cagayan Mayor Oscar Moreno. At ito po mga pending case nito ay kasalukuyan ding dinodouble check ng JBC dahil pwede po itong maging grounds pa sa disqualification ng isang nominado dahil hindi nga po pwede na kapag ikaw ay nag-a-apply bilang associate justice na meron kang criminal or administrative cases. Dito naman po tayo magtungo sa mga sagot ni CA Associate Justice Ami Lazaro Javier. Siya po ay dating naging Assistant Solicitor General. Ayun nga po, nung tinatanong siya ni Justice Cayosa, ang gusto niya bilang siya po ay umatende ng mga bar examination, ang nais niya lamang ay magkaroon ng magandang kombinasyon ang multiple choice question at yung pagiging essay. Ito ay para makatulong na rin syempre na mabuo yung scientific basis syempre nung ating mga kababayan. Samantala, ito namang si Mr. Joseph San Pedro ay isang private practitioner. Ang habilin nga kanina ni Chairman Gutierrez sa kanya maganda yung experience niya sa pagtuturo sa law school at hindi matatawaran iyon. Ngunit, syempre bilang isang associate justice, kinakailangan din ng kaunting linya pagdating sa litigation. Kaya dahil nga wala siyang experience doon sa paglitigate, medyo napansin din yun ni Honorable Gutierrez. Kasama na rin syempre yung attire nitong si Attorney San Pedro. Siyempre makakasama natin ngayon si Attorney Cynthia Rojas para mabigyan tayo ng iba pang mga insights tungkol doon sa nangyari. Attorney Cynthia.
Magandang umaga uli, Kirby. Ngayong araw nito, nakita natin na actually yung mga in-interview ngayong araw na to hindi masyadong controversial. In fact, the last interviewee, si Attorney San Pedro, yung pagki-question sa kanya ni Justice Gutierrez, very brief, nakakagulat kasi during the past interviews, sinasabi na maraming tanong si Justice Gutierrez tungkol sa mga legal issues, pagkatapos mga questions, yung mga national issues. Pero ito, ngayon, medyo nag-focus yata dun sa age ni Attorney San Pedro. Di ba?
Attorney Cynthia, kanina nung nag-uumpisa yung public interview, inuna nga itong si Justice Romulo Borja. Kanina, nabanggit na naman yung case resolution. Gaano ba ka-importante na mabilis tumugon ng isang justice sa pagresolba ng mga case resolution, lalo pag uupo na sa bilang associate justice?
Alam mo, kasi ganito yun, di ba? Ang Supreme Court, ang pinakahuli na final arbiter of all legal issues. Ngayon, kung mabagal mag-resolve, ang mga tao nagagalit na nga sa judicial process. In fact, marami na nga hindi naniniwala dito dahil ang sabi nila, ang hustisya raw ay para lang sa mayayaman, ang gulong ng hustisya ay napakabagal kung gumulong. Ngayon, I think the Judicial and Bar Council is trying to vet nominees na talagang sa kanilang palagay makakatulong sa pagbilis ng proseso ng pagresolba ng mga kaso. Ang dami, libo yun Although, kaya nagiging issue palagi sa mga nominees kung sakasakaling mabagal sila mag-resolve ng mga kaso.
Balikan naman natin, Attorney Cynthia, ito namang sunod si CA Associate Justice Ami Lazaro Javier. Medyo maganda yung mga punto na binigay niya kanina, habang tinatanong siya nung mga wall panelists. Isang bagay na rito yung hindi niya pag-agree doon sa inilabas na desisyon ng Korte Suprema sa Marcos Bureau. Ang sabi niya rito, ang conviction daw ng tao ang pinakamataas na conviction. Kaya wala daw pwedeng court na pwedeng mag-assume nito unless magkakaroon ng people power. Your thoughts on this, ma'am?
So makikita natin dito, si Justice Ami, very independent. So isa sa mga requirements at qualifications ng ating mga nominado para sa Associate Justice ng Supreme Court ay kailangan hindi siya natitinag, hindi siya nakikinig lalo sa mga political pressure, hindi siya takot. At nakita natin to kay Justice Ami. Hindi siya takot na magsabi na siya ay maninindigan sa kanyang paniniwala.
Isang bagay pa po yung tinanong naman sa ni Honorable Gutierrez tungkol naman po dito sa posisyon niya on the extrajudicial killing. Tinanong sa kanya kung crimes against humanity o isa bang genocide ito. Ano po ba ang magandang sagot na ginawa niya?
That was a very lengthy discussion, And I see from what I heard nung nakikinig ako sa kanyang mga sinasabi, very purist si Justice Ami. Talagang sinitingnan niya, she sticks to the wordings of the law so that at least kahit papano, dun siya naninindigan, sinusunod niya. So naniniwala ako na if ever Justice Ami gets to the Supreme Court, she will really stick by the provisions of law.
Attorney, gaano ba kahalaga yung pagka ini-interview ka ng isang wall panels at umupo ka bilang aplikante, kailangan yung attire mo ay presentable dahil nga kanina napansin kay
Attorney San Pedro, Oo. Kasi ganito, kagaya ng sinabi ni Justice Gutierrez, this is a very momentous occasion for any applicant. Like, you are applying for the highest position in the judiciary. So parang sinasabi lang dito na dapat handa ka, not only by the questions, but that you are presenting yourself to the public. And sa pananaw ni Justice Gutierrez, personal appearance adds to the personality or the qualifications of a possible nominee.
Isa pa po, napansin ko rin kanina, nabanggit na, sabi nga ni Honorable Gutierrez na maganda yung records niya sa pagtuturo sa law school. Ano? But ang problema, wala siyang experience pagdating sa litigation. Gaano ba kahalaga, Attorney Cynthia, na ang isang nag-a-apply bilang associate justice ay may experience under litigation?
But I think Attorney San Pedro tried to debunk that. No? Sinabi niya na totoo, hindi siya humaharap sa korte, subalit siya naman ang nasa likod. Litigation din ang kanyang linya dahil siya yung nagpupush ng pleadings. Kaya nung tinanong siya kung sa iyo bang pananaw ay ikaw ay magaling na pleader, yung gumagawa ng mga papel, sinabi niya oo, kasi research siya And I think that will be an advantage for him when he gets to the Supreme Court dahil ang Supreme Court, hindi naman yan, very rare naman din yung mga oral arguments. A lot of them will be really how you decide cases. So ito magiging strength na. Kaya lang at the end of the interview with Justice Gutierrez, medyo hinagod siya doon na sinabi, bata pa siya, dapat marami pa siyang daanan. So bumalik daw siya pagdating ng 60 years old. So medyo that was cool point, no? Parang just to break the ice siguro on the part of Justice Gutierrez. But that did not mean that Attorney San Pedro's not gonna get the votes. Ang sinasabi lang dito, perhaps he could wait kasi baka there would be some sense of maturity that he could acquire with an additional 10 years for his application.
Attorney, napansin ko rin, no, kahapon pa, talagang nagiging issue yung edad ng mga aplikante. Especially, kanina nabanggit din kay CE Justice Romulo, kanina yung edad niya na 68. Tinanong nga siya, pag upo niya ng January, ilang buwan na lang yung matitira sa kanya. Gaano po ba kahalaga na kailangan hindi ka tumungtong na malapit ka na rin magretiro bago ka maging associate justice?
Importante to, no? Kasi as soon as you get appointed to the Supreme Court, hindi naman yan automatic, alam mo kung ano yung pinapasok mo, di ba? There is what you call parang an acclimatization period, di ba? So kailangan you get to use to the processes. Kasi this is a collegial body. Lahat ng, kumbaga, sabay-sabay kayong magde-decide. Hindi ito isang tao lamang. So kung 24 months na lang ang iyong oras or panahon para maging justice, parang naiisip lang siguro nung mga nagtatanong sa panel, ano pa ang iyong pwede magawa sa 24 months na ito? Baka kulang ang panahon na to. Sa isang banda, marami naman ding sinabihan, kagaya ito nga, si Attorney San Pedro, 50 years old pa lang siya. Kahapon, meron ding 50 years old, di ba? So parang nga sinasabi dito, age does matter. I think for the Supreme Court, yes, it does matter because one, yung maturity siguro minimeasure din dito. Yung aside from the experience and the academic excellence, minimeasure ng JBC lahat. Which brings us to, ano ba talaga function ng JBC? It is the body which vets applicants. Natanong kanina ni Justice Gutierrez, di ba, tungkol dun sa pag-abolish ng JBC. At ang sinabi ni Attorney San Pedro, which I believe was a good answer, kailangan baguhin ang konstitusyon. Dahil ito ay itinalaga sa konstitusyon and only a constitutional amendment can change and even abolish the JBC.
Attorney Cynthia, ano na ba ang susunod? Right after na matapos na po itong lahat ng public panel interview, ano na po ang susunod na aabangan po ng atin pong mga kababayan?
Okay. This morning, I was listening to Justice Mejia, and he said that although the public interviews are finished today, this morning, the 4 regular members will be joined by the 3 ex-officio members, the Supreme Court Chief Justice Lourdes Sereno, the Secretary of Justice Vitaliano Aguirre, and the representative from Congress, either Senator Gordon or Congressman Ray Umali, as members of the House Committee on Justice. So itong 7 na to will go into a legislative session. I understand that their timeline is only 2 weeks for them to come up with a short list. And according to tradition, parang a minimum of 3. And hindi sila naglalagay ng cap kung ilan ang maximum. Pero ang sinasabi nila, this will be a minimum of 3 per vacancy from which list the president can choose his actual appointee.
Sakali po ba na magawa na po, attorney, itong shortlist at maipepresenta na po kay Pangulo at sakali po na may mapili na si Pangulong Rodrigo Duterte doon po sa shortlist, ang susunod po ba once na matapos na magretiro yung mga justices like Jose Perez, Associate Justice Jose Perez and Associate Justice Arturo Brion, mag-a-assume office na po yung napili?
Depende yon, ano? Pero anyway, this is an innovation of the JBC. Dati, they will only get nominee or they will only talk to open the application process kapag nag-retire na. But I think this is an innovation of the JBC. They foresee that these retirements will happen, kaya nag-i-interview na sila para magkaroon ng shorter time sa backlog or sa shorter time sa vacancy na makakreate ng mga pag-retire ng justices. Ang una magre-retire is Justice Jose Perez, and the other one who will retire shortly thereafter is Justice Arturo Brion.
Attorney Cynthia, yung paglalabas nung pag-televise po ng public interview nitong mga aplikante, gaano po ba kahalaga na nalalaman po ng ating mga kababayan yung pagsala dito sa mga aplikanting ito?
I think this is also in tune with the times, di ba? Kasi mas concerned na tayo. I think the JBC just wants to make the vetting process very transparent para nakikita ng mga taong bayan sino-sino ba ang umaharap para sa mga gustong mag-apply sa highest court of the land, the Supreme Court. Pero tatandaan natin, no, hindi lang ang JBC processes the applications of all members of the judiciary, of all the collegiate courts. So kumbaga, kaya lang very special ang justices ng Supreme Court kasi sila nga yung last arbiter ng ating judicial system. Kaya tama lang para sa aking pananaw na malaman ng taong bayan kung sino ba ang mga dapat na kino-consider. Kaya lang, Kirby, no, ang importante dito nating sabihin sa mga tao, hindi ibig sabihin na kahapon we had 4 and then 3 in the afternoon and now only 3.
Correct.
Nasasampu lang ang mga kandidato para sa vacancy nito. If we go by the list of the JBC, there are at least 18 nominees for the position to be vacated by Justice Perez. And another 17 for the vacancy of Arturo Brion. Although, meron mga nagdodoble, and I think in the case of Attorney San Pedro, isa lang ang inaplayan niya, kay Justice Brion lang. Some others like Attorney Acosta, I think all the others na sumalang, lahat yata sila, dalawa yung kanilang application.
Nabanggit ko nga po kaninang umaga nung mag-opening ako yung pangalan po ng mga nasa listahan, ng mga valid pa rin po yung interview. Itong mga interview na to, attorney, meron bang validity year kung gaano katagal lang or
1 year. Ang sinasabi ng JBC, if you have been interviewed by the JBC for 1 year, pwede yon. So if you apply for another vacancy, for example, yung mga na-interview, can you imagine kung every time merong vacancy ay sila ay magi-interview? Aba, wala na nga ang gagawin ang JBC. You see, very comprehensive ang study, ang background check ng JBC. So you have to give them credit, Yung kanilang sinasabi na resolution rate, yung mga kahapon sa kaso ni Assistant Secretary Paras na ungkat yung kanyang ombudsman case, no? So makikita natin dito that the JBC is trying to make this an apolitical process as possible. They are going through all the qualifications and they are scrutinizing each and every candidate.
Speaking of that case, kanina rin po nabanggit yung kaso with si Justice Romulo Borja. Sabi nga po kanina mula po kay IBP Attorney Honorable Cayosa na meron siyang pending case in line with Mayor Oscar Moreno ng Cagayan. Pagka ganito ba, Ma'am Attorney, ano ba yung possible na mangyari sakali po na maging active yung kaso at magkaroon ito ng resolusyon?
O kaya nga. Kaya dito, they are trying to avoid the situation where there would be cases. Kasi eventually, if they are not happy with the resolution in the administrative body, aakyat ito sa Supreme Court. And can you see the situation kung sakasakali na nandun sa taas? At tapos ang question na nililitis ay yung mismong kaso ng Associate Justice na yon. Kaya I think the JBC is just really trying to do its homework. It's trying to check and double check all the nominees para kung sakasakali at sa kanilang paningin at kanilang pananaw, ito ay makaka-apekto sa kanilang duties and functions as an Associate Justice, then siguro baka magmamatter ito. Ito ay magiging, it will have some bearing on the possible application or nomination process of that particular applicant.
Attorney Cynthia, sa mga social media meron napapansin po ng ating mga kababayan na talagang inaabangan na magtanong palagi ay si retired Associate Justice Angelina Sandoval Gutierrez. Sa tingin niyo po ba kaya po ganun kalalalim yung tanong niya sa bawat aplikante ay may linya to doon sa kanyang experience bilang Associate Justice dati.
Kaya nga, ang isa sa mga members ng JBC ay isang retired Supreme Court Justice. Bakit? Kasi sila yung nakakaalam kung ano yung magiging trabaho sa loob ng tribunal. See? So, always, I share your point, no? Si Justice Gutierrez palaging inaabangan ng mga tao. Bakit? Sa kanya nanggagaling yung mga medyo mahihirap na tanong. Yung mga current issues, yung mga ano ang direction na tatahakin ng particular candidate kung sakasakaling sila ay ma-appoint. So, very ticklish ang nagiging mga questions ni Justice Gutierrez, which I know that the public appreciates kasi nakikita nila yung insight tungkol do sa particular na kandidato na yon. Hindi ba, Kirby?
Opo. And lastly, attorney, before I let you go, yung pag-upo po ba, kasi napansin po natin sa mga dating public panel interview, dumarating ang isang non-member po ng Judicial Bar and Council na dati po, si Congressman Tupas ay nagtanong din po kung inyo pong maaalala, no, sa mga aplikante. Parang sa ngayon po, parang walang non-member po na umattend ngayon. Discretion po ba yun, Attorney Cicero?
Well, there are members. They are all members of the JBC. If they want to propound questions which they feel are relevant to the candidacy of a particular nominee, they can do so. But in the past 2 days, nakita natin, hindi yan minarapat o the other ex-officio members deem it necessary to come in and ask their questions. They probably feel that the members of the JBC are competent to have asked or to be asking ano man yung mga questions. Sa kanilang pag-iisip siguro ay kailangan maitanong. Siguro sa akin lang, no, the fact that they have not appeared here means that they have full faith and confidence in the other members na itatanong yung mga very ticklish and controversial, if ever, issues sa mga ating mga aplikante.
At last na, baka may last words po kayo, Attorney Cicero, sa ating mga kababayan.
I'd like to say that the public should watch out not only for this process. Kailangan ng ating bantayan ay yung mga kandidato ngayon, sino ba ang final na mapipili dito sa shortlist. We should remember that the JBC's function is to give the shortlist, and it is only from this shortlist na dapat ang presidente ay pumili. Nasa Constitution yon. The president can only choose a candidate from this shortlist. So, let us pray for enlightenment for these JBC members who will meet very shortly for executive session to vote for all these nominees to these 2 vacancies for the Supreme Court.
Alright, well said. Maraming salamat, Attorney Cicero, sa
Kirby.
pagsama po ninyo sa amin. At syempre, para matulungan po kami na maipaliwanag po sa ating mga kababayan.
Of course, meron tayong mga kaibigan na tumulong para maging successful ang ating pagpapasahing papawid ngayon. Kirby,
Exactly.
sino sila?
Would like to acknowledge, of course, hindi po magiging posible ang special coverage ito sa tulong po ng Manila Pavilion Hotel and Stop sa pangunguna po ni Franz Eschenauer, ang siya pong General Manager. Kasama rin po si General Manager Jelly Annabel Kahulugan, ang Marketing Communications Officer, Chief Engineer Edwin Katindig, Assistant Chief Engineer, maging ang Security Department po na si Chief Falcon. Maraming salamat po sa mga tulong na ipinagkaloob niyo po para maging posible ang special coverage na ito. At syempre, antabayanan niyo po ang mga susunod pang kaganapan. Diyan na po nagtatapos ang ating pagtutok sa naganap po na public panel interview. Dito po yan sa loob ng division hearing ng Korte Suprema ng Judicial and Bar Council. Ako po ang inyong lingkod, Kirby Cristobal. Isang magandang araw, Pilipinas.